Welcome to this episode of Divorce, Parenting and Property Matters, Legal Insights by Village Family Lawyers, where we share practical family law insights for people navigating separation, parenting and property matters. Today we're talking about the difference between a binding financial agreement and consent orders and how to work out which one your situation actually calls for. You've reached an agreement with your former partner. After everything it took to get there, that feels like the worst is behind you. And in most respects, it is. The hard conversations are done. Then someone asks whether you're doing a binding financial agreement or consent orders, and it turns out there's one more decision waiting when you thought you'd finished. The two get described as alternative routes to the same place. They're not quite. They behave differently, and the difference generally shows up later rather than now. So let's take them one at a time. Consent orders first. You've agreed on something and you apply to the Federal Circuit and Family Court of Australia to have that agreement turned into orders. A judicial officer looks at it. They have to be satisfied the terms are just and equitable before they'll make the orders. If they think it's too one-sided, they can decline. Once made, it's a court order. If somebody doesn't do what they agreed to do, you have enforcement options straight away. Now the binding financial agreement, this one never goes near a court. Nobody checks whether it's fair. It's a private contract between the two of you, and it draws its force from a set of strict formal requirements being met exactly. The most important of those is that both people received independent legal advice before signing, separate lawyers, not one lawyer for the pair of you. So that's the contrast. One is checked and immediately enforceable. The other is private and flexible, and it depends entirely on the paperwork being right. Here's where each one earns its place. The financial agreement can do something consent orders simply can't, which is exist before a relationship ends. It can be made before you move in together during the relationship or afterwards. That's why it's the instrument people use when they're protecting a business or an inheritance or assets they brought in with them. Once a relationship has ended, that option is gone for that relationship. It's also more flexible. Because no court is measuring the terms against a fairness standard, you can structure things a court wouldn't order. And it's private. For some people, that's the whole decision. There's one more advantage, and it's the strongest of them. Where an agreement is properly made and meets every requirement, it can operate to exclude the court's power to make property or spousal maintenance orders about the things it covers. That's a genuine closing of the door. It's also exactly why the requirements are so strict. Consent orders earn their place wherever compliance isn't certain. If there's any real doubt about whether the other person will follow through, enforceability is worth more than flexibility. That's often the case where trust has broken down or where obligations run over months and years rather than completing at settlement. They're also the answer if children's arrangements need formalising because a financial agreement can't deal with parenting at all. Not a single clause. Some couples use both. Consent orders for the parenting side, a financial agreement for the money. Now the part people don't ask about, and should, binding financial agreements get set aside. Not often, but it happens, and it happens for reasons that were entirely avoidable, where a party didn't disclose their full financial position, where someone was pressured into signing, where the independent legal advice wasn't properly given, where circumstances relating to a child have changed so much that holding people to the terms would be unjust. None of that is a reason to avoid a financial agreement. It's a reason to have one prepared properly by someone who does this work regularly. So how do you choose? 4 questions. Is the relationship over? If it isn't, a financial agreement is your option. Do children's arrangements need formalising? If so, you need consent orders or a parenting plan for that part, regardless of what you do about the money. How confident are you that the other person will comply? Genuine confidence and a clean break points toward an agreement. Any real doubt points toward orders. And do your terms sit inside what a court would order? If your arrangement is conventional, consent orders cost you very little. If it's unusual, an agreement may be the only way to get there. Reaching agreement is the hard part, and you've done it. Choosing the right document to hold it is what makes sure it lasts. If you're at that point and you're not certain which one fits, that's a short conversation rather than a long one. An initial consultation covers your position, the right instrument for your circumstances, and what each option means in practice. You can book at villagefamilylawyers.com.au or call 1300 413 997. This has been Divorce, Parenting and Property Matters. Legal Insights by Village Family Lawyers. Thank you for listening.